Hello, everyone. How's everybody enjoying their morning or middle of the nightness, depending on where you're at in the country? I quite the interesting things. That one girl, howdy, good to see you. Woody Boots, yes, I am doing a middle of the night live stream because I've learned about some interesting possible case law here. I haven't fully really looked over this. I only gave it a quick glance, but it looks to be an interesting read. Early morning roll call. Oh, definitely if you're on the East Coast in the military. It's 70 degrees out. Not where I'm out, obviously. It's what, let's see here, 2 something in the morning. But, as is, I figured this would be a good time to go through some case law here. Hello, everyone. Yes, I see quite a few night owls with me here. So let us go ahead and get started on the fun part. As is, I only got a quick brief. I know it involves filming police and possibly case law establishing for the first time that you have a right to film a police stop or something like that. So, or at least in a court case law thing. And just remember that if this turns out to be case law, this only applies to Hawaii, not like a portion of the United States. It's done in the state Supreme Court. So you'll have to excuse me if I'm not paying attention completely to the chat because I'll be busy reading State of Hawaii versus Thomas RUSSO. Blah 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 blah. Skipping past that part. All right. This case arises out of a 2012 incident that occurred on the shoulder of Halike Kala Halike Highway. I'm probably mispronouncing all that. In Maui County, while Thomas Russo was filming police officers conducting a traffic enforcement operation. During Russo's filming of the traffic stop with his cell phone, he was arrested for interfering with government operations and other offenses. Russo was subsequently charged with failing to comply with a lawful order of a police officer, an offense for which he had not been arrested. Russo has consistently maintained that his filming of police activity was protected by the United States and Hawaii constitutions. If the highlights, okay. Anyway, continue on. We join those jurisdictions that recognize that there is a constitutional right of the public to film the official activities of police officers in a public place, but because we concluded that the record does not support a finding of probable cause that Russo failed to comply with the police officer's order, we do not address whether Russo's constitutional right to access and film the traffic stop was infringed in this case. Accordingly, we vacate the intermediate Court of Appeals summary disposition order and affirm the district's court order that dismissed the case with prejudice. So, according to this, if I read this correctly, included record does not support the finding of probable cause, failed to comply with the police officer's order. So, the lawful order thing is not part of this case, it looks like. Anyway, continuing on. Facts and procedural history. On November 20th, 2012, Russo was arrested on the highway by Maui Police Department (MPD) officers Rusty Lawson and John Fairchild for obstruction of government operations, resisting arrest, and harassment. Russo was later charged by complaint with failure to comply with lawful order or direction of a police officer in violation of Hawaii Revised Statutes 29C-23 back in 2007. I guess it was the last revision of that. And disorderly conduct in violation of HRS 711-1101, subsection 1, subsection D, 2003. At arraignment on January 24, 2013, Russo pled not guilty to the charges. So those are the facts right there of the bare minimums of what we understand. Okay. Motion to dismiss. On December 27th, 2013, holy cow, that was quite the time between arraignment and and motion to dismiss there. Russo filed a motion to dismiss the case against him based on the First Amendment to the United States Constitution, or alternatively on the grounds that there was no probable cause to support the charges. In his motion to dismiss, Russo contended that this case was about a police officer arresting a journalist covering a news story because the officer did not want to be filmed. Specifically, Russo contended that he was the publisher of Maui Times publications, and engaged in investigative journalism regarding current events, the arts, and other news of Maui County. According to Russo, on November 20th, 2012, he pulled over onto the shoulder while driving along the highway to investigate an ongoing law enforcement operation. Russo began filming two police officers who were conducting a traffic stop and was arrested for obstructing government operations shortly thereafter. Very interesting there. Let's see. In his motion to dismiss, Russo argued that the First Amendment to the United States Constitution protects the right to take photographs and videos of public places, which include the right to film the activities and operations of police officers. Russo contended that the First Amendment right to record police activity is limited only by reasonable time, place, and manner restrictions. Russo submitted that he had complied with all police orders given to him by MPD officers at the traffic stop that he was filming. That his recording was from a safe distance, and he did not obstruct the officers conducting the stop. Thus, according to Russo, the case against him should be dismissed because his conduct was protected by the First Amendment. Let's see here. In an alternative, Russo contended that the case should be dismissed for lack of probable cause. Russo submitted that the charge of failure to comply with a lawful order and police officer officer was unsupported by probable cause because he was actually complying with police officers' orders and directions. Russo also argued that the statute under which he was charged did not apply to this alleged failure to comply with the officer's order because the law prohibits a driver from ignoring a police officer's traffic directions, not an officer yelling at someone on the side of the road. Ooh, that's an interesting little part there. Additionally, Russo argued that the disorderly conduct charge should be dismissed because he was not disorderly or persisting in a disorderly conduct, nor was there any evidence that he was creating a hazardous or physically offensive condition. We got a little citation there. In response, the state argued Russo did not simply want to record the traffic stop, but wanted to interfere with the administration of the stop. The state acknowledged that other jurisdictions had held videotaping public officials to be protected under the First Amendment. The state submitted, however, that this right has limitations and subject to reasonable time, place, and manner restrictions. That right there reminds me of what's going on with the 8th Circuit currently. The state contended that the MPD police officer determined that the area where the traffic stop was being conducted was not a reasonable place to film police because it was not safe, and Russo's actions in entering and remaining on the traffic stop area were therefore not constitutionally protected. According to the state, Russo failed to comply with directives to step back and to cease interfering with the traffic stop and to stop resisting arrest. Thus, the state submitted the officers exercised proper caution in addressing the situation, and probable cause existed to support the charges. Now, this is quite interesting because they're trying to pull the reasonable time, place, and manner restrictions, but often, I'm not currently in Oregon, but that's where I'm currently residing, guys. But getting back to this, the thing is, with the time, place, and restrictions, it's a public roadway, and he's on the side of it. Now, people are allowed to protest and hold up signs on the side of the road or a highway for the most part. So makes me question the specifics, but let's continue on with the learning more about this case here. The hearing on Russo's motion to dismiss. Drink some water here. All right. At the hearing on Russo's motion to dismiss, the state called MPD officer Rusty Lawson to testify regarding the events leading to Russo's arrest. Officer Lawson testified that he had been employed by MPD for 8.5 years, and at the time was time assigned to Traffic Division DUI Task Force. On November 20th, 2012, Officer Lawson was 2012. Officer Lawson was assigned to conduct a specific traffic enforcement called Operation Recon, during which MPD sought to enforce traffic regulations uh, relating to lift vehicles, tires extended beyond the fenders, window tint, and any other traffic violations MPD could see. Officer Lawson testified that he was acting supervisor of the operation, which involved between 5 and 7 officers, and that that he and Officer Fairchild were positioned in the same area on the side of the highway. Officer Lawson testified that he was conducting a traffic stop for a possible window tint violation prior to his interaction with Russo. His unmarked police vehicle was parked on the grassy shoulder of the highway, as was Officer Fairchild's vehicle, and the vehicle belonging to the individual subject in the traffic stop. Okay. At this point, Officer Lawson's testimony, the state played the video recording comprised of 3 individual clips taken by Russo, showing the events leading up to Russo's arrest, which had previously been stipulated into evidence by the state and the defense. In the first clip, Russo holds the recording device 6 is a reference, and can be heard speaking in the background. The device appears to be taking video from behind the windshield of a vehicle parked on the shoulder of the highway in which Russo is sitting. The video depicts Russo exiting his vehicle and walking towards the cars parked in front of him. The camera pans along the highway as Russo narrates that the road is backed up with traffic. The camera then focuses on vehicles parked ahead on the side of the highway, and 2 uniformed police officers wearing orange and yellow vests are seen walking near the vehicles. Russo continues to walk towards these uniformed officers, and one of the officers, subsequently identified as Officer Fairchild, can be heard asking Russo to turn his hazard lights on. Russo replies, sure, I can do that. Officer Fairchild then walks back towards the parked vehicles, and Russo appears to be walking back towards his vehicle. Interesting. So the first thing that the officers tell him when they spotted him parked on the side of the road is to turn on the hazards, not that he was filming. So let's continue on and see what's going on here. In the second clip, the recording begins with the camera pointed towards Russo's parked car. The vehicle's hazard lights are on. Russo appears to begin walking towards the vehicles parked ahead, where Officer Fairchild and the second uniformed police officer, identified as Officer Lawson, are standing. In the third and final clip, which appears to be an immediate continuation from the second clip, Russo continues to walk towards the vehicles parked ahead. Russo comes into proximity with the closest vehicle, which appears to be an unmarked police car. Fairchild, who is standing next to the first unmarked vehicle, sees Russo approaching and appears to wave his hand. Russo comes closer to the officer, and the officer again appears to wave his hand to indicate the shoulder of the highway, and it states that Russo that the police are pulling people over in this area here. Russo then questions Fairchild as to why the police are pulling people over, to which officer responds, traffic violations. Russo asks Officer Fairchild whether he thinks it's justified to black traffic all the way up to, I'm not sure how to pronounce this, I'm going to screw this one up, Hali Mali? Yeah, I probably butchered that one. Russo asks Officer Fairchild whether he thinks it is justifiable to back traffic all the way up. Oops, I'm reading the same sentence. Regarding the extent of the surrounding traffic, the officer again waves his hand along the highway shoulder and states to Russo, "We're pulling, I guess, cars over in this area right here. So please step off to the side. I don't want you to get ran over." Russo responds, "Okay." At this point, Russo appears to begin walking away from Officer Fairchild and towards the second unmarked police vehicle, which is parked immediately behind the car subject to traffic stop. Officer Lawson can be seen standing at the driver's side window of the vehicle subject to the stop. As Russo approaches the area, parallel to the front passenger side of the stopped vehicle, Officer Lawson leaves his position at the driver's side window, walks around to the front side of the vehicle towards Russo. The following exchange occurs. I wonder if I should get my voice acting on. Lots of talking, lots of water. Officer, excuse me, sir. Russo, yes, sir. Officer, can you stand back there? Can you stand back there? Don't come over here. The traffic stop being conducted. Can you stand back there? As Officer asks Russo to stand back there, he points backwards in the general direction of Officer Fairchild and Russo's parked vehicles. In response, the Officer Lawson's request, Russo answers, no, I'm inaudible. Russo interrupted by the officer, who states, "You're obstructing government operation." Russo responds that he is not obstructing at all, and appears to walk backwards away from the officer. Again pointing in the general direction of Russo's vehicle, Officer Lawson states, "Don't intervene, this is a traffic stop. You need to stand back there." Russo can then be heard asking, "Where can I stand?" Russo walks a few steps to the right, away from the highway, towards what appears to be an adjacent field, and asks, "Can I stand here? This is private property, right?" The officer appears to indicate to Russo he cannot stand there, gesturing again in the general direction of Russo's vehicle and saying, "You can stand back there. You're on private property." Russo then takes several steps back towards the highway, closer to the officer, and asks, "Can I stand on public property?" At this point, Russo can be heard telling Officer Lawson, "Don't. Are you touching me? You're touching me." Officer Lawson then places his right hand on his belt and states, "I'll arrest you for obstructing." Russo repeats that he is not obstructing anything, and it relays he has got video. Russo begins walking backwards again, away from the officer, towards Russo's car. Officer Lawson continues to walk towards Russo, repeatedly stating, "There's a traffic stop back here, and I'm asking him to stand back there." Officer Fairchild then joins Officer Lawson, and both continue to walk around towards Russo's car as he backs away. As he walks backwards away from the officer, Russo states there is more than a traffic stop. This is a circus, and repeats that he is not obstructing anything. Officer Lawson responds that he told Russo 5 times and states that he will place Russo under arrest for obstructing government operations. Russo then identifies himself by name and relates that he is a member of the media. He continues to walk backwards, and Officer Lawson continues to approach him. Russo can be heard stating twice, "Don't touch me, officer." Officer Lawson states, Sir, you need to comply." To which Russo responds, "I am complying, officer. I am. Huh. Boy, quite the interesting interaction there. And it seems familiar in a way. The camera tilts down towards the ground as a scuffle ensues, at which point the video recording suggests Russo is placed under arrest. An officer is heard telling Russo, "Stop resisting, stop resisting." And at that point, officer was, "Sorry about this." Russo replies, "I'm not resisting. I was walking backwards, just as the video shows." Russo can be then heard stating, No, you're not allowed to take my phone." At this point, the video footage concludes. Huh. Well, this does remind me of something. This reminds me of when I got arrested in Anchorage a couple years back with President Obama visiting. And how I was walking backwards, and I just briefly paused as I'm retreating, and they arrest me for trespass. And of course, those charges were dismissed because they didn't have good standing with the way the law was written. Plus, also, it's already established case law, too, within the state of Alaska. After the state played the video, Officer Lawson testified he directed Russo to step and or stand back around 5 or 6, 7 times. He also testified regarding the procedure that the MPD has in place concerning media contact. When asked to describe MPD's policy governing when members of the media are permitted to film police activity, Officer Lawson suggested that the MPD may in some situations require pre-approved media pass. Oh, hasn't there been a huge battle in the past couple years over media passes and what's valid and what's not? Yeah. So this is gonna get a little bit more interesting. I don't think it governs as far as filming the police, but I believe it's I guess, a courtesy request of the media to contact the police department for, I guess, what they call like a media pass. Any media from the police department has to go through our chief. I cannot make any statements of the media, but if such they wanted to come and give, I guess, a courtesy to guys or to the guys or in the media to have like a sit-in or like a ride-along, that's no problem as long as it's cleared with the chief of police. Officer Lawson further testified that he was not notified by MPD that the media would be recording the police during the Operation Recon. Now, here's the thing. This is one hell of a misconception. One that's actually in the past several years. It's been 5 years since this incident happened. Um, that police, you do not need permission to film police in a public area. And it appears that the police officer was under the assumption that, oh, in order to film me, you got to get permission, especially when I'm doing a traffic stop. And 2012, that's when the whole First Amendment filming the police, well, the filming the police and First Amendment audits and tests and all that stuff really started kicking off. I think Honor Your Oath was going on before this. There was only like 3 or 4 people that were active um, filming police and traffic stops and all that stuff before this incident happened. So it wasn't really pushed out there. Yeah, as what is it? Miss Blink, I think it is, states they want to make the police look good. Yeah, anybody who is having the media attention shine upon them, they want to have the media make them look good. That goes for, I mean, that goes for us, that goes for the police, that goes for the criminal defense, the accused, the big corporations. Everybody that's going to get put in front of the camera want to be in their best appearance and all that stuff. And so of course they want to have that control of narrative within, I mean, a greater extent. Anyway, let us continue on with this. Okay, just read that part. Officer Lawson further testified that he was not notified. Okay, no, I just read that one. Okay, following Officer Lawson's testimony, the state called to the stand the individual subject to the traffic stop that was occurring at the time of Russo's arrest, the witness. The witness testified that during the traffic stop, she observed Russo with the phone, but did not know what he was taking a video recording, and well, that he was taking video recording until she was told by Officer Lawson. The witness stated that she did not feel scared during the incident, and she never told Officer Lawson that she felt threatened. Oh, that looks like this is blowing up in the prosecution's face. Also, the motion to dismiss proceeding, the defense elected testimony regarding national standards of care applicable to filming police officers in public from Mickey H. I'm not going to try to pronounce that last name, who was qualified by the court as an expert witness in the area of film journalism, photography, and journalism. Okay, I'm going to try to pronounce this. Oh, screw it. I'm going to just say Person O. Person O testified that based upon his review of the video footage, Officer Lawson's directions throughout the encounter were unclear and were not reasonable time, place, or manner restrictions. Russo emphasized that in his closing argument that the orders were too vague to comply with, arguing that Officer Lawson never, sir, can you move 15 feet away? And instead it said only, go over there, go over there. On July 9th, 2014, the district court issued an oral ruling finding the facts, finding of fact and conclusion of law regarding Russo's motion to dismiss. In its FOFs, the court found that Russo's complied with Officer Fairchild's request that he turned on his hazard lights. The court also found, however, that Russo was instructed multiple times to step back out of the area where the officer stopped was occurring. The court determined that Russo did not comply with the order to step back and continued engaging the officers. In addition, the court determined that the instructions to step back were not specific as to time, place, manner, or manner as testified to by defense experts. Personnel there. In its COLs, the district court concluded that probable cause did not exist for the arrest of Russo on either charge. The court determined that HRS 291, which sets forth the offense of failure to comply with lawful order of a police officer, did not apply to Russo's conduct. The court reasoned that under HRS 291, the provision parts 3 and 14 of the traffic code relating to the operation of vehicle refers exclusively to the operation of vehicles upon highway, except where different place is specifically referred to and given the section HR 291C-21. Because the offense of failure to comply with the lawful order of a police officer is codified within Part 3 of the traffic code, the court determined that pursuant of HR 291C, the offense only applies to conduct relating to operation of vehicles upon highways. And since Russo conduct did not involve operation of a vehicle upon a highway, the court reasoned that the offense of failure to comply with lawful order of a police officer did not apply. Oh, so I'm wondering who filed the objection to this one, the appeals court. With respect to charge of disorderly conduct, the district court concluded that the evidence was entirely unclear as to whether, by failing to follow officers' directions, Russo created a hazardous condition posing risk of physical inconvenience or alarm to members of the public within the meaning of disorderly conduct statute. The court thus determined that there was no probable cause to support the charges. Regarding Russo's argument based on First Amendment, the district court concluded that Russo's burden to establish that his rights were infringed and that he failed to do so. The court determined that the case did not involve police officers objecting to Russo's videotaping, but rather Russo's failure to heed their instruction based upon their view that he was hindering their operations. The court also concluded that Russo had not satisfied the burden of demonstrating that the instructions given by the police were unconstitutionally vague as to time, place, and manner. However, the court determined that it did not have based decision on the constitutional question in light of its ruling. The district court thus dismissed both charges for lack of probable cause and entered a notice of entry, a judgment, or order of dismissal, which dismissed both charges with prejudice. The state timely filed a notice of appeal to the Intermediate Court of Appeals from the order of dismissal. So, okay, district court thus dismissed. Okay, so the court dismissed the charges with prejudice, but the state appealed. So yeah, figures as with the ending of that one. The state took this to the Supreme Court. They vamped this one, it looks like. And so and this sort of falls in with the whole thing of where exactly what went wrong here. And so far from the facts that are given to us, in this case that we are seeing, the officers were giving him instructions. Now, the issue is, were the instructions lawful orders, or were they unlawful? And in my opinion, the instructions the police were giving out were not lawful orders, due to the fact that obviously he was standing at some distance or something like that away from the police scene, and he was walking backwards, and they arrested him in the process of while he was walking backwards away from the scene. And so the question is how close was he? Oh well, we'd have to probably pull the records and look at the video or something like that, and I might be able to do that. It's hard to say. But let's go ahead and take a quick look at the comments here. Let me pull up my little comment listing here. Whoops, I did not mean to close that one. Reopen, close tab. Where's my live stream for thing? Because I think most of these people are chatting in on here. Oh yeah, that reminds me. Anybody chatting on Twitch? No, no one said anything on Twitch. So back to the YouTube. Maybe have. I'm guessing you are guy standing. I was wondering, Southern Illinois Public Observers. Looking for more comments that are related to what we got going on here. Uh, it looks like we got just a bunch of sidebar in the conversations. Any more? Yeah, just mostly sidebar conversation, it looks like, guys. But it's nice to see you guys enjoying the chat, and not to mention it showing up on the thing here. They seem perplexed. Yeah, they do seem perplexed. Yeah, Twitch, yikes. I understand yikes, but how should I put it? I'm expanding the civil rights influence, I guess you could sort of say. That was you. No, I'm not sure what that comment's referring to. But this is quite the entertaining thing, and we're just barely scratching the halfway point on this. I suspect. Let's see here. How much further down? Okay, so this ends right about there. Okay. Do. Lawful order, discussion, standards of review. Okay, I was up a little bit further. But this is quite the interesting, lengthy read. Okay, hearing motion to dismiss. I passed it. I did. Go figure. Okay, yeah, ICA proceedings. That's where I was at. Lots and lots of reading. All right, continuing on. In summary, disposition order (SDO), the ICA concluded that the district court erred in dismissing the charges of failure to comply with a lawful order of police officer. The ICA determined that the restrictive language in HRS 291 means that were specific provisions of HRS Chapter 291, Parts 3 and Parts 14, related to the operation of vehicles. Only operation of vehicles upon highways is covered unless different place is specifically referred to in the provision. The failure to comply with a lawful order was not limited to operation of vehicle, ICA reasoned, and therefore could be applied to Russo's conduct as a pedestrian where he interacted with the police officers who were regulating traffic. Ooh. So yes, the state was the one that wanted to contest this because they didn't like the fact that they just established case law in their state at the appellate level that further limited the lawful order restrictions. Pretty much what's happened here. The ICA considered whether the probable cause supported the charge. The ICA determined that probable cause did exist to support the charge of failure to comply with a lawful order of a police officer, relying on the following factual findings of district court. Russo was informed by officers involved in the traffic enforcement that he was in their area of operation and in danger of being struck by a vehicle. Russo was told multiple times to step back out of the area of operation by two officers. 3. Russo did not comply with the officer's instructions. Ooh. Well, that's sort of debatable right there because you arrested him as he was walking backwards away from you guys. The ICA's majority therefore concluded that the district court erred in dismissing the charges of failure to comply with lawful order of police officer in violation of HRS 291C. Accordingly, the ICA vacated the district court's order of dismissal and remanded the case for further proceedings. Chief Judge Craig H. Nakamura issued a concurring and dissenting opinion in which he agreed with the ICA's majority interpretation of HRS 291 291C-21 and 291C-23, but he disregard that the charge for failure to comply with a lawful order of a police officer in the case was supported by probable cause. And the chief judge stated that his review of the video footage showed that although Russo questioned the officer's authority to order him from the scene, he was complying with the officer's order, retreating and walking backward away from the approaching officers and their area of operation when the officers arrested him. Ooh, see, I just was stating this too. That the guy was retreating and walking backwards as the officers were given, as he was questioning the officers' instructions. That's going to be a nice little, that's an important fact right there. Chief Judge Nakamaru, hope I'm pronouncing that right, this concluded that the probable cause was lacking because the video recording shows Russo did not willfully fail or refuse to comply with the officer's order to stand back or move, and that any finding made by the district court to the contrary was clearly erroneous. Thus, Chief Judge Nakamura would have affirmed the district court's dismissal of the failure to comply charge on the alternative ground that the insufficient probable cause existed to support the charge. Standards of review. Probable cause determinations are reviewed upon on appeal under a de novo standard, State v. Kalahano, Hawaii, back in 2002, and then State v. Navas in 1996. So there's some extra case law for reading up later on for those that are wanting to do more research. A court finding of the fact are reviewed under the clear erroneous standard, finding the fact clearly erroneous when despite evidence to support the finding. The appellate court is left with a definite and firm conviction in reviewing the entire evidence that a mistake has been committed. Reciting another court case from '94. A court conclusion of law where are reviewed under the right-wrong standard, which allows the appellate court to examine the facts and answers the question without being required to give any weight to the trial court answer. Quite interesting, and citing another court case from 1995. The interpretations of a statute is a question of law reviewable de novo. Another court case from 1996. Two court cases from 96. The court answers the question of constitutional law by exercising our own independent judgment based upon these facts. Another one from 2001. A lot of different case laws being cited here. Thus, the question of constitutional law are reviewed on appeal under the right-wrong standard. All right, so this is starting to get interesting here. Okay, discussion. In his applications for writ of, I'm not even certain, how is that pronounced? Okay, I'm gonna Google this one real fast. Let's see here. I'm just gonna use a text-to-speech thing to see if I can get this. Okay.
Certiorari.
Certiorari. Okay. I'm not even gonna try to pronounce that. What is the Oregon Bar? The Oregon Bar is the legal association that deals with certifying lawyers to practice in the state of Oregon. Each state has their own bar association that has their own testing. And so, let's say I get a law degree and I want to practice law in Oregon. I would have to go through the bar association and pass their test to be legally allowed to practice law within that state, at least at the state level, on that issue. Anyway, continuing on. Russo argues that the district court correctly dismissed the charge of failure to comply with lawful order of police officer for lack of probable cause, and thus ICA erred in vacating the order dismissal. Russo contends that even if the ICA concluded that the district court's interpretation of HRS 291C23 was incorrect, the ICA was obligated to affirm the dismissal order on the alternative ground that there was no probable cause supporting the complaint against Russo. Specifically, Russo submits that there was no proof that he willfully failed or refused to comply with the police officer's order. Russo also argued that the ICA majority erred in not considering the merits of his First Amendment argument that he has a constitutional right to film police activity. Subject to reasonable time, place, and manner restrictions, In addition, Ruscio submits that the district court wrongly concluded that he had the burden of proof to establish that the police instructions were unreasonable and the command to stand away from the traffic stop was too vague to be reasonable time, place, and manner restrictions. To resolve the merits of Ruscio's argument on Centauri or whatever how you pronounce that, it's going to take me forever to practice that one. We considered whether the ICA correctly concluded that the charge of failure to comply with lawful order of police officer was supported by probable cause, because ICA failed to address Ruscio's constitutional argument when it vacated the order of dismissal, and because of the determination of whether the police officer's order was lawful within the meaning of HR as 291C-23 depends in part whether the order comported with the state and federal constitution. We also addressed the existence of the constitutionally protected right to photograph and film police officers in public. Oh, now we're getting to start to tear this one apart. Need some water here. Mouth going dry. Lots of reading. Okay. Starting off, a lawful order and First Amendment implications. A person commits the offense set forth in HRS 291C-23 when a person willfully fails or refuses to comply with any lawful order or direction of a police officer authorized by law to direct, control, or regulate traffic, HR 291C-23, emphasis added. Thus, necessary predictated to find the guilt under HRS 291C is the existence of a lawful order or direction by police officer. At the motion of dismiss proceeding and on appeal, Ruscio has argued that irrespective of compliance or alleged noncompliance with the officer's order to stand over there or step back, this order was not lawful within the meaning of HRS 291C, because it infringed on his First Amendment right to photograph and film police in public, officers in public. The state appears to acknowledge the existence of First Amendment right, but contends that Ruscio's actions in entering or remaining in the traffic stop area were not constitutionally protected, and that the officer's order was a reasonable restriction. The district court declined to expressly rule on First Amendment grounds, but concluded that it was Ruscio's burden to demonstrate that the order was unconstitutionally vague as time, place, or manner, and Ruscio had failed to make this showing. The ICA did not consider any constitutional implications of the officer's conduct when it vacated the district court's dismissal order and remanded the case for further proceedings, despite the fact that Ruscio had argued that the ICA to affirm dismissal on First Amendment grounds. Ooh. So they managed to bring back the whole constitutional and legal part when it came to further review of this case and the facts around it. Although not addressed by the ICA, the constitutionality of the officer's order to stand or step back inextricably intertwined with the state's allegation that Ruscio violated HRS 291C. If the order did not comport with the federal and state constitutions, the Hawaii revised statutes, or any or other principles of law, it was not lawful within the meaning of the statute HRS 291C. Would this thus impose no requirement of compliance. Further, the issuance of a lawful order or direction is an essential element of offense set forth in HRS 291C, thereby indicating, contrary to the district court's conclusion, it is the state's burden to prove the existence of a lawful order, rather than defendants to prove the order was unlawful. Accordingly, we address the existence of First Amendment right to photograph the film, the police, and its limitations. That's interesting, right there. So pretty much, what the court said in the appeals was that the burden of proof of proving the lawful order was unlawful was on the defendant. When actually, when it comes into the Supreme Court here, that The proof is not on the defendant. The proof is on the state's side to state that the order was lawful in the first place. So the burden of proof is on the state to prove that the order was lawful. That's exactly what's happened here. And because the issue of the First Amendment right to film and photograph police is at play, it brought back in the civil rights issue on that. Because the question is, okay, is he allowed to stand there in a public place and film where he was at? But let's go ahead and continue on with this. This is getting quite interesting. This is the meat right here. Hello, person on Twitch. Nice to see the unique emoticon there. The First Amendment to the United States Constitution states, in relevant part, that Congress shall make no law abridging the freedom of speech or the press. U.S. Constitution Amendment 1, Article 1. Section 4 of the Hawaii Constitution likewise provides that no law shall be enacted abridging the freedom of speech or press. Constitution section 1, Part 4. The court has interpreted the free speech rights afforded by the Hawaii Constitution to be at least as expansive as those provided by the United States Constitution. See Corsby v. State Department, some sort of Hawaiian case law from 1994. Indeed, we have considered that in some circumstances, this court may find the Hawaii Constitution affords a greater free speech protection than the federal counterpart. Ooh, that's interesting. So you have more free speech rights in the Hawaiian state afforded by the Constitution. Quite interesting. So let us continue on. Although the First Amendment does not explicitly protect the right to film or photograph matters of public interest, the United States Supreme Court has long recognized that its protection does not end at the spoken or written word. Texas v. Johnson, 1989. Okay, I'm going to have to definitely come back, and that's going to be a case law I'm going to want to look at right here. Part of the way I do the research, when I do researching, is when I'm reading through these case laws, keep an eye on when they cite other case laws from other areas or jurisdictions and stuff like that, and check those out. It's amazing how much you can learn just by going through and checking out all these other case laws. Okay, and they cite another one from Hawaii. Okay, another case law from Hawaii stating that First Amendment is broad enough to encompass those rights that, while not unambiguously enumerated in the very terms of the amendment, are nonetheless necessary to the enjoyment of the First Amendment rights. Quoting a case from 1982. Out of Norfolk. Okay, so that one's probably going to be another one I'm going to need to read. The court has likewise considered that news gathering may receive constitutional protection because without some protection for seeking out news, freedom of the press could be eviscerated. This one looks to... Yeah, this is another Supreme Court case, I'm guessing. Brandsburg v. Hayes, 1972. So those that want to do additional research, we're going to definitely want to look at this one at a later point. See also Hitchens v. KQED, 1978. There is an undoubted right to gather news from any source by means within the law. Quoting Brandsburg, this understating of the First Amendment serves the core function of prohibiting government from limiting the stock of information from which members of the public may draw. So just in this one paragraph, we may have just uncovered additional tools that we can use for doing First Amendment tests and First Amendment auditing. This is really good information, really important stuff. I probably might end up clipping this later, or making this a sub video. Okay, this understanding of the First Amendment serves function prohibiting government. I just read all that. The Constitution. Let's see. Yeah, okay, and then we got First National Bank of Boston v. Bulletti. The constitutional safeguard extends beyond the protection of the press. The First Amendment protects the public right to access of information about officials' public activities. Fields v. Philadelphia, Third Circuit 2017. And here's a case where they refer to another circuit, um, the Third Circuit Court here. This is a Third Circuit decision. This does not have Hawaii's in the Ninth Circuit. Now, when it comes to case laws at the that are created at the appeals level, federal level, those generally immediately apply to that circuit. And right now, there's two specific case laws within the Ninth Circuit that cover this issue, but they also reference a decision out of the Third Circuit. Now, when it comes to actual the court battles, you can refer to other appeal circuits for arguments, saying this is what they decided and when it comes to this subject issue. So, with all the rulings that we have with the filming of police in the various circuits around the country, this is very handy because each time we add a new circuit onto the list, we don't have to take it to the Supreme Court. We just got to get a majority, which I think we already do have a majority of the circuits, stating that we have a right to film public officials or the police and all that stuff. Sorry, I'm burping here. Probably got too much air in my stomach from all this talking. Continuing on. Based on the principles, numerous jurisdictions have held that the First Amendment affords individuals the right to photograph and film police officers in a public place. In Glick v. Cunniffe, for example, the First Circuit Court of Appeals held that filming government officials engaged in their duties in a public place, including police officers performing their responsibilities, is protected by the First Amendment. The First Circuit explained, gathering information about government officials and from that can be readily be disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Quoting Mills v. Alabama, 1966, promotion of free discussion of government operations is particularly desirable in the context of law enforcement officials because it may aid in the uncovering of abuses and have a sultry effect on the functioning of government and more generally. See also Gentile v. State Bar of Nevada, 1991, observation of disseminating information relating to the alleged government misconduct lies in the First Core Amendment. And I'm going to pause here for a moment, and I want to address something that has been a sort of a bane for people that have been doing First Amendment tests and audits with post offices. And the thing is within the policy of the post office, their own established policy, they say you can't film their workers in the public area. Well, there's a problem. We have case law that states that we're allowed to film government officials out of the First Circuit, which applies to all government officials that are acting in public capacity. So I don't know. I think I need to sit down and start building up a case dossier specifically around with challenging the post offices. The post offices need some a hit there, and just within this case, this ruling here, we uncovered a ton of information that easily applies to all this. And so for like those the people like News Now Alaska, this is where I got my information. Remember what I was telling you. This is how I find it. And for anybody else, for like everybody that's down there in LA and stuff that's having trouble with filming in the post offices and stuff like that, I recommend if you just read through like these paragraphs within this case law and pull out and go and check out these other case laws. Look for information that helps stand up the argument of civil rights when it comes to filming in the post office. And then, of course, like have that all that information ready. Okay, get back down here. What is continue on, because this is getting really good. I'm really enjoying this. Several other federal courts have likewise concluded in light of these considerations, individuals have a constitutionally protected right to photograph and film police officers. Oh, whoa. Hey guys, recognize this name here, this court case? C. Turner v. Lieutenant Driver of the 5th Circuit, 2017. We agree with every circuit that has ruled on the question. Each concluded that the First Amendment protects the right to record police. The Batosai, your case law has been referenced this year in another court. Congratulations. Your work in Texas has done awesome. This is the first time I'm able to sit down and read someone that's doing the civil rights stuff, the filming the police and all that stuff, is being their case law that they established is now being cited in other case law. So this shows you that the work that we're putting in, it takes forever. It's a long, hard challenge to push in, but it's having an effect. We have a reference to a case law that our people, the people are doing civil rights stuff that are filming the police, have created. Continuing on here, Smith v. City of Cumming, out of the 11th Circuit, recognizes the First Amendment right to photograph or videotape police conduct because the amendment protects the right to gather information about what public officials do in public property, and specifically a right to record matters of public interest. Flores v. City of Seattle, the 9th Circuit, this one that covers the 9th Circuit in Hawaii, recognized the First Amendment right to film matters of public interest and to gather news in context of police officers' alleged assault and battery against individual filming the police officers assigned to the work at a demonstration. ACLU of Illinois v. Alvarez recognizes the First Amendment to protects audio and audio-visual recording and gathering of news information, particularly about affairs of government in context of civil liberties organizations' plans to make audio-visual recordings of police officers and disseminate the recordings to the general public. See, this is where knowing the case laws and bringing about the right arguments for your court case are very important. Recently, the Third Circuit Court of Appeals, this is another case that I need to read. This was just decided actually this year. The right of bystanders to record police officer performing their official duties. The Fields Court noted that to record the police there is a right to for eye to see and the ear to hear. Lays aside the subjective impression for objective facts. To record record is to see and hear more accurately. In addition to the valuable benefit of recording to facilitate the discussion and broadly distributed, the Third Circuit observed the proliferation of bystanders videos has spurred action at all levels of government to address police misconduct and to protect civil rights. These videos have helped police departments identify and discipline problem officers. They have also assisted civil rights investigations and aided in Department of Justice work with local police departments. In the act of recording, regardless of what is recorded, may improve policing and particular personal concerns to police is that bystanders' recordings can exonerate an officer charged with wrongdoing. At 360, internal citations and quotation marks omitted, Fields Court understood that in order for the First Amendment protection to having the First Amendment must also protect the act creating that material. Courts have sorry, I need to drink some water here. Boy, this is very important and very interesting read. Courts that have held that the First Amendment protects the right to photograph and film police officers in public have also concluded that the right is not without limitations. Glick, rather, the ability to film law enforcement officials in course of performing their duties may be subject to reasonable time-place restrictions. See also Turner, in reference back to Turner. In Glick, the First Amendment Circuit determined that it need not address the specific parameters of what constituted a reasonable time, place, and manner regulation, because the individual's exercise of his First Amendment rights fell within the bounds of the Constitution for protection. This was because his filming was in a public park. 2, he video recorded a police officer from a comfortable remove and neither spoke nor molested them in any way, except when indirectly responding to officers when they addressed him. And 3, Recording was peaceful and did not interfere with the police officers' performance of their duties. Quoting, I'm not sure how to pronounce that, Akiba v. Butler, First Circuit, 1999. In Garrick v. Biggin, First Circuit, 2014, the First Circuit squarely addressed the issue of time, place, and manner restrictions that it left open in Glick. And Garrick court first rejected an argument that holding in Glick did not apply to filming of a traffic stop, holding that First Amendment principles apply equally to filming a traffic stop and filming an arrest in a public park. However, the court reiterated that the right could be limited by reasonable time, place, and manner restrictions where the circumstances justified them. The First Circuit didn't specify that a time, place, and manner regulation could be issued by law enforcement to an individual filming police performing their duties in a public only if the officer can reasonably conclude that the filming was itself is interfering or is about to interfere with the officer's duties. Interesting. So they have to reasonably conclude that the filming itself is interfering in some way. We agree with the reasoning that the First Circuit and the other federal courts of appeal that have considered the issue. The rights to free speech and press serve not only to protect the individual's right to self-expression, but also to promote the vital goal of affording the public access to discussion, debate, and dissemination of information and ideas. Exercising the constitutionally protected rights to free speech and press plays a crucial role in informing the education, the public offering criticism, and providing a forum for discussion and debate. At 71, thus the aspect of First Amendment is all more critical when the ideas of information sought to be disseminated pertain to the government officials and law enforcement personnel, who are granted substantial discretion that may be misused and to deprive individuals of their liberty. See also, from Glick, see also Gentile. Public access to the information serves to guarantee public oversight of law enforcement and to minimize the possibility of abuse by ensuring that the police department and officers are held accountable for their actions. Pure News LLC v. City and City of Honolulu. I guess that's something that's established within the state, within their own state. In light of these principles, this court likewise concludes disciplinary records under state. Oh wait, no, sorry, I started off in the wrong spot. Considering accessibility of police officers' disciplinary records under state public records law. In light of these principles, the court likewise concludes that filming government officials engaging in their duties in public place, including police officers performing their responsibilities, is protected by the First Amendment of the United States Constitution and by independent protections afforded by Article 1, Section 4 of Hawaii's Constitution. We also agreed that this right is subject to reasonable restrictions as to time, place, and manner of the photography recording, reference to Glick. Such restrictions may be necessary to ensure that law enforcement officials are capable of carrying out their duties and maintaining their safety of both the general public and the individuals conducting the photography and videography. We are persuaded that the threshold requirement for the issuance of time, place, and manner restrictions as set forth by the First Circuit and Greeky strikes the appropriate balance between ensuring public safety, preserving law enforcement efficacy, and protecting constitutional free speech and press rights. And I noticed the person that commented, am I doing speed? No, I'm not. I'm just excited because there's interesting new information that I want to read up and study. Thus, we concluded that the constitutionally granted right to photograph or film the activities of police officers in public may be limited by time, place, and manner restrictions, so as long as a reasonable officer would conclude that the individual actions is interfering or about to interfere with the police officer's performance of his or her duties. If issued, a police officer's order pertaining to time, place, and manner filming must be narrowly. I need to drink some water here. Okay, and I see a Turner reference right here when I was coughing. If issued, police orders pertaining to the time, place, or manner of filming must be narrowly tailored to mitigate the action, danger, or risk posed by recording and leave open ample alternative channels to engage in the protected activity consistent established in principles of First Amendment jurisprudence. See Turner. And let's see. Let's see Turner, Alvarez, Blas of 1981. A quote here discussing permissibility of issuing time, place, and manner restrictions on constitutionally protected speech. Okay. So State v. Bloss is another issue on that issue, on the time, place, manner. As necessary corollary to the requirement that the time, place, and manner restrictions be narrowly tailored, leave open ample alternative channels for photographing and video recording. The restrictions in context must also be specific and clearly and unambiguously communicated by the officers. See State v. Gutian. Okay, that's another specific for the state of Hawaii case law. Quoting blah blah another state for that. Okay, here's a quote from a 2000 case law, holding that the court injunction whose violation subject a party criminal penalties must state in terms clearly and unambiguously and allow a person's ordinary intelligence to understand what acts are prohibited. Thus, the order or direction must be sufficiently clear to specific so that the ordinary individuals exercising their constitutional rights to free speech can readily identify the conduct that the order is prohibited. So the idea, observing that the requirement of particularity and specificity, can't speak now. I'm losing my ability to speak. Specificity are based in part upon the concepts of fairness and due process, which dictate that the court order must be sufficiently and particularly and definite as to clarify and identify the conduct that it prohibits. Clarity and specificity, I'm screwing this up, are all the more important in the context of the offense charged in this case. Under HRS 291C, mere lack of compliance with a police officer's verbal order or direction renders conduct unlawful, otherwise may be lawful and constitutionally protected. So let me drink and take another sip of water here. Okay. Anyway, what we just read here is that the officer has to specify clearly that pretty much an eighth grader could understand where the line is of where they exercise, instead of stand over there, which is vague, which I'm gauging from this. The officer needs to say, I need you to stand 15 feet over there, or I need you to stand right next to that car, or his car, or the car over there, or stand next to that tree or pole. You gotta be very specific. Or don't get within 15 feet of this traffic stop or this vehicle that's here. You gotta be very clear. I'm not sure what the comment was there on Twitch there, or about Twitch. I'm gonna take a quick break here. And I want to ask questions here. What do you guys think of all this stuff that's going on here? Just quite the interesting information that we're finding, isn't it? What service phone does Bunny Boots use? His glide quality is okay. I use currently my phone service is going through GCI, and so that is a local company up here in Alaska. Though down stateside, in the lower 48, it seems to be defaulting to T-Mobile when I'm streaming down there. Unless there's crime scene tape. Yeah, well, yeah, that would make it an obvious thing of having crime scene tape. That would be shutting down an area to everybody. As far as they demand, I saw a kid 2012. Yeah, but this is quite quite the interesting like information discovery that we have going on. And I've been streaming for over an hour, and we're finally getting near the end of this. As I said, I have not really. This is the first time I'm reading through all of this here. Our safety is not the police's responsibility. Uh, that is partially true. Think useless blah blah blah. And further discuss sidebar conversations going on. That's nice to see going on. Let's see here. Let's see. Interesting information. Very good. Very helpful info. That is for sure. I do agree that the info is really good. Let's see here. So let's go ahead and continue on. Mere lack compliance, verbally directed, protected. Okay. I might have to take a pre-break. Hopefully, I can get done with this before I need to go to the bathroom. Okay. In this case, Ruscio was engaged in video recording officers Lawson and Fairchild as they conducted a traffic stop pursuant to a scheduled law enforcement action. Whether he was acting in an individual capacity or as a representative of the media, Ruscio's conduct in videotaping police officers in public was protected by the First Amendment to the United States Constitution, Article 1, and Section 4 of Hawaii Constitution. Officer Lawson and Fairchild were entitled to issue directives to regulate the time, place, and manner of Ruscio's video recording so long as the officers possessed an objectively reasonable belief that Ruscio's interfering or about to interfere with the ongoing traffic stop. Assuming the officers so concluded, any orders or commands they delivered were required to be clear, specific, and narrowly tailored to mitigate the actual danger or risk posed by the recording. The directives were required to leave open ample alternative channels to observe the officer's activities. In light of our disposition of other issues, we do not determine whether the officer's order to Rosio satisfied these requirements. Rather, we observe that in our society, police officers are expected to endure significant burdens caused by citizens exercising their First Amendment rights, and to ensure the protections that the First Amendment affords. Officers may often be expected to show restraint when they are merely the subject of videotaping that memorializes without impairing their memorializes. I think that's how you memorialize. I'll have to look up the pronunciation on that word. Without impairing their work in public spaces. Reference to Glick once more. So essentially, what they are stating that they need that the orders were too vague with that in layman's term. DC Metro, London Metropolitan area. There's a lot of places that a lot people that need testing. Okay, now we're on to part B. The compliance with officers' orders. This should be a fun one. Probable cause to support a charge is established by the state of facts that would lead a person of ordinary caution or prudence to believe and contentiously entertain a strong suspicion of guilt of the accused. State v. Atwood, Hawaiian Supreme Court 2013, and then another one, Supreme Court, Hawaiian Supreme Court, State v. Chong 1993. Although the evidence need not be sufficient to support a conviction, this court has concluded that the requirement of probable cause is at least as demanding as purportance of the evidence stated standard. State v. Bagnus, another Hawaiian case, 2005, interpretation of probable cause as requiring lesser quantum of proof than purportance of the evidence standard as an unreasonable attempt to water down the requirements. I've never seen quantum used in that method. I'm going to have to look up. There's a lot of words I'm going to need to look up definitions to here. In this case, the parties agree that the best evidence is the video itself. and the parties stipulated the video into evidence. In its oral ruling on RUSSO motion to dismiss, the district court made findings based in large part on the video footage of the events leading up to and including RUSSO's arrest. The court determined that RUSSO was advised by MPD that he was in the area of operation where cars were being pulled over, and that he was in danger of being struck by a vehicle. The court then found that RUSSO was instructed multiple times by Officer Lawson and Fairchild to step back and out of the area of operation, but RUSSO did not comply with the instructions to step back and continued to gauge the officers. The ICA majority concluded that these findings by the district court demonstrated the probable cause existed to support the charge against RUSSO for failure to comply with the lawful order a police officer in violation of HRS 291C. On Centauri, I can't pronounce big words right now. To this court, RUSSO argued that the conclusions drawn by the ICA and district court with respect to his compliance are inconsistent with the evidence because the video recording clearly and unequivocally shows that he complied with officers' orders to stand and or step back. The video footage stipulated into evidence by the parties shows that RUSSO did, in fact, comply with officer's order. When Officer Fairchild instructed RUSSO to return to his vehicle and turn on the hazards, RUSSO complied. When Officer Fairchild waved his hand and directed RUSSO to step off to the side to avoid getting run over, RUSSO likewise complied, responding, "Okay," and walking away from the general area to which Officer Fairchild had gestured. When RUSSO was subsequently approached and ordered by Officer Lawson to stand back there, RUSSO complied by taking a few steps away from the area and asking where he could stand on private property. When Officer Lawson responded that he could not and ordered him to stand back and stand on private stand back losing my place here. Stand back there, RUSSO took several steps back towards the highway and asked, "Can I stand on public property?" When Officer Lawson threatened RUSSO with the arrest, RUSSO immediately began walking backwards away from the area towards the general direction in which Officer Lawson and Fairchild pointed. For the remainder of the video, the police officers persisted in walking towards RUSSO and commanding that he stand back there. RUSSO continued to walk backwards away from the traffic stop area. It appears from the video that recording that RUSSO only stopped walking backwards when he was physically prevented from doing so by the arresting officer. Ooh. So what are they going to say in this last paragraph? Although RUSSO may have continued to engage Officer Lawson and Fairchild in conversation and questioning during the encounter, the video itself plainly demonstrates that RUSSO obeyed their command. RUSSO appeared to make a concerted effort to comply with the officer's instruction, and the video shows that he walked away or backwards when ordered by the officers to step or stand back. The parties agreed that the video footage was the best evidence of the encounter. The footage impels the conclusion that RUSSO did in fact comply with officers' order. Thus, given the evidence in the case, there was no probable cause to support the charge of failure to comply with the lawful order of the police officer in violation of H.R. 291. C. The facts and circumstances as added by the parties at the motion to dismiss hearing would not cause a reasonable person to believe and contentiously entertain a strong suspicion, let's see, underneath cited case law, that RUSSO was willfully failing to refusing to comply with any lawful order issued by Officer Lawson and Fairchild, as stated by the video evidence that shows RUSSO was complying with the officer's orders. Thus, ICA erred in concluding otherwise. Big tackle face when the pig tackled her. I think you're probably referring to the lady that got smashed into the wall. I have seen that video footage. I don't really have a comment on that because I don't know enough facts about that issue. In conclusion, Although District Court incorrectly concluded that HRS 291C did not apply to Russio's conduct and dismissed the failure to comply charges on the basis, the court may affirm the judgment of lower court on any grounds in the record that supports affirmance. Even if that ground was not expressly relied upon by the lower court, State v. Fukuoka, um, what's the Hawaii court case from 2002. Here, an alternative basis for dismissing the charge applies, namely that probable cause was lacking as to the charge of failure to comply with lawful order of police officers pursuant of HRS 291C. Although ICA correctly concluded that the district court erred in its interpretation of the statute, the ICA erred to the extent that vacated the district court's dismissal order and remanded for further proceedings after determining that the probable cause existed to support a charge against Russio under HR S 291. Accordingly, we vacate ICA's May 1st, 2017 judgment on appeal and affirm the district court's July 9th, 2014 notice of entry judgment and or dismissing charge against Russio with prejudice for lack of probable cause. And then below here is footnote citations for a lot of their stuff, which there is quite a bit. So in conclusion, what did the court find? Where the court found that Russio had First Amendment rights to film, in that be there. What also found the Supreme Court of Hawaii also stated that the probable cause for the charges of failing to comply with officers' orders there was not substantiated. It wasn't valid in this case, due to the fact he was complying and he had constitutional grounds to be where he was at, or at least be able to have a reasonable place to film in that location. And so what happened was going through, I guess there were several other court cases that this has been through the ringer a couple of times, it looks like. Whatever was decided by the ICA in earlier this year was thrown back to what was decided back in 2014, stating that there is no case for these charges to be put in. So we have a mixed bag here thing, but as is, this does affirm that people have a First Amendment right within the state of Hawaii to film the police, citing multiple federal case laws from the appellate courts across the country, and also several different citations from within the state itself. And the fact also that within the state of Hawaii, police have to establish, when they're given a lawful order that is around issues of exercising First Amendment rights and stuff like that, the orders have to be clear and concise. So they can't stand there and say, I need you to stand back. They need to state, I need you to step back, step back another 5 feet, or I need you to stand outside this area like 15 feet. They got to set up clear boundaries when it comes to filming of police and filming or just the exercise of rights in general. So this is quite the interesting read, quite the lengthy one. This has gone on for nearly 90 minutes. And what are your guys' opinions? I'd love to. Anybody in the chat here have any good opinions on this one? Not if it makes sense. More sidebar stuff. Let's see, Bunny Boutique, did you see? Okay, that's one I read earlier. A couple times here. Anything on the Twitch one? Let's take a look at the Twitch chat here. Nope, nothing new over here either. Back to the live chat. But it looks like most of the people here are having fun, having sidebar conversations. There definitely needs to be nationwide boundaries. Yes, but we're working on that. It's not an easy task. Bringing change is a long and arduous fight. And that's part of the reason why we're trying to set things up where we can be able to better push these changes and get additional regulations, case laws, and stuff like that, so we can have better protections across this country. Can this be used in other state court laws? It can be referenced, possibly, but I have never seen, so far within all the looks for, at least within other states, case laws, I haven't seen them reference case law that's been established in another state. They will reference federal case law, but not state case law, to my knowledge. As is, I'm not a law student. I'm not a lawyer or anything like that, so I can't give you a clear-cut answer on that specifically. There might be a case out there, and I've only been reading case laws and stuff like that for maybe 4 years, I think now. So I can't really can't give you an exactly informed a statement or opinion on that matter. Do 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 do. Am I still in frame? Yeah, I'm still in frame. So, but as is, when this live stream ends and becomes a video, you'll be able to find the case law on the YouTube archive for this, for those that might end up watching on Twitch or Periscope. And that's pretty much about it. I think I should probably go ahead and end the stream, get some sleep here, and I got some other stuff. That's why do they care about the boundaries. Yeah, no, that's fine. Of course, BBI didn't, all of the states are the best example of what should be. Yeah, well, as is, each state has their successes and failures when it comes to law and all that stuff. But I recommend for those that are wanting to get involved with civil rights or are actively involved in civil rights, there's that one section uh, I would recommend going through and looking at the reference and how they decided that, because there is some good arguments in there for and against with the filming of police, or the at least the restrictions, and knowing that information will um, better make you be able to justify or articulate the restrictions that the police have if you're having an argument with an officer on the side of the road or whatever, or if you're going to end up, you got to fight this in court by yourself. And thanks, Drewy, for the thank you there. Anyway, I think I will go ahead and end the stream. Thank you all for being here. Oh, and before I forget, the music that you heard in the intro was made by Technoax. He does royalty-free music. That specific song name is "Stopping the Madness." It was produced. Well, it was published on YouTube December 12th. You're able to use that music royalty free on your channel. He has a huge collection of music that's available to you, so just keep that in mind. That's part of the usage policy. The terms to using it for free is you have to give some sort of accreditation to him, either in the description or through a verbal saying it as a credit or something like that. You gotta get proper credit. But anyway, it's been easily over, just surpassing 90 minutes of doing this live stream. And I hope you guys have a good night or a good morning, since I know people are waking up on the East Coast and probably checking this out. I will probably have some more case law reading later on this week, and for starting this will probably become more of a regular thing where I'm gonna sit down and just start reading case law to you guys. So I hope you guys enjoyed it, and I'll go ahead and allow the song to finish off as I tune out here. Oh, where's my studio mode? Ah, excellent. And you guys have a good evening.